This training is intended to comply with the New York State regulatory and legal requirements for mandatory staff trainings in the topic areas of corporal punishment and the Dignity for All Students Act. Let's dive into corporal punishment, timeouts, and physical restraints. In New York State, regulations were updated in 2023, whereby school districts have to adopt new definitions and new policy documents with respect to corporal punishments, timeouts, and physical restraints and the uses of them. Policy locations at the Waverly Central School District are on your school district's website, Board of Education tab, and board policy documents. Definitions to be aware of. Aversive interventions are interventions that are intended to induce pain or discomfort for the purpose of eliminating or reducing student behaviors. Examples could be noxious or painful intrusive stimuli, contingent food programs, meaning I will give you food only if you behave, movement limitations, and such examples would not include voice control, ignoring behavior, token fines, physical prompts to interrupt behavior, or medically necessary interventions. Next, corporal punishment. Corporal punishment is a definition we all should be really familiar with. It's an act of physical force for the purpose of punishing a student, not including physical restraints. De-escalations is another common term most of you should be familiar with. It's a use of behavior management techniques to help a student increase control over their emotions or behaviors and results in a reduction of present or potential level of danger. Mechanical restraints are the use of a device or equipment to restrict a student's freedom of movement. Multi-tiered systems of supports are proactive and preventative frameworks that utilize data to inform instruction and the allocation of services to maximize achievement for all students and support students' social, emotional, and behavioral needs from a culturally responsive and strength-based perspective. A physical escort is a temporary, I want to underscore, temporary touching or holding of the hand, wrist, arm, or shoulder or the back for the purpose of inducing a student who is acting out to walk to a safe location. This would not include grabbing the wrist or an arm of a student and dragging them through the halls of a school building. Physical restraint is a personal restriction that immobilizes or reduces the ability of a student to move their arms, legs, body, or head freely. Physical restraint does not include physical escorts or brief physical contacts or redirections for the purpose of prompting a student or calming a student, etc. Prone restraints are physical or mechanical restraints while the student's in a face-down position. This is prohibited. Also prohibited, so no school district employee or agent, an agent would include an SRO, school resource officer, you absolutely cannot engage in corporal punishment, aversive interventions, seclusions, or prone restraints. Specific use of timeouts and physical restraints. First, you always have to use proactive, positive evidence and research-based strategies through multi-tiered systems of supports to reduce the occurrence of challenging behaviors and to eliminate timeouts and physical restraints. This is your exhaust every other option before you use a timeout or physical restraint. However, if you get there, you've exhausted those options, all other options, then you can engage in a timeout or physical restraint if there's no least restrictive and intrusive intervention as an option. There's no known medical contraindication for the use of timeout or physical restraint. An example here would be if a student had broken legs, you wouldn't want to engage in a physical restraint involving the legs. That would be a medical contraindication. School staff using the technique have to be trained. You cannot use to punish or discipline, and you cannot use to substitute, again, for the positive proactive intervention strategies. Let's shift gears and talk about timeouts specifically. In addition to those general requirements I just covered, timeouts can only be used in such a fashion. So let's talk. You have to return to the students to the educational program or as soon as the student has safely de-escalated, regained control, and they're prepared to meet expectations. Additionally, the actual room or space that you use for a timeout have to be unlocked and able to be opened from the inside. They have to be monitored by both seeing and hearing the students by a staff member. You have to be the room space or space has to be of adequate width, length, and height to allow the student to move and recline comfortably. It has to be clean and free of objects or fixtures that could be dangerous to the student. You have to meet, of course, fire and safety codes. The walls and the floors, if practicable, have to be designed to prevent injury with adequate lighting and ventilation. The temperature is in normal comfort range. Staff, again, you have to monitor continuously, and if you are a staff member monitoring timeout, you have to be trained. In addition to the general requirements that I posed 2 slides ago, physical restraints also have additional requirements. Before engaging in a physical restraint with a student, you have to use the type of physical restraint that's most least restrictive and discontinue it as soon as the danger is gone. You never can use a physical restraint in a manner that restricts the student's ability to breathe or communicate or harm them. Of course, it can't be a prone restraint. It cannot be used as a planned intervention on an IEP, 504 plan, or BIP. It cannot be used to prevent property damage. This is a new update in 2023. It used to be you could use reasonable physical force or restraints on students to protect property. No longer the case. That's done. Only could be administered by staff that are trained. So this is your TCI trained staff or TCR its equivalent. And following a restraint, medical personnel and the nurse need to check the student out. Crisis intervention and prevention procedures and de-escalation. So New York State does have a requirement that we touch on at least prevention. Prevention of student behaviors, of course, you would want to create a positive culture and climate, create a calming environment, meet students' needs, provide them with adequate resources, and encourage and build positive relationships with them, and address bullying. Crisis intervention or de-escalation, those are topic areas beyond the scope of this training today, but of course you can reach out to your district office to get to obtain further information and guidance on where you can get additional resources. To the next topic now, on to the next topic, DASA, preventing harassment and bullying of students. So what is DASA? DASA is the Dignity for All Students Act. It's found in education law, Article 2, and it prohibits discrimination, harassment, and bullying of any student by employees or other students. So it protects a student. It does not protect staff. It requires school districts to create and implement policies and procedures and create a school environment that's free from such conduct. Other sources of law in New York State that protect students that we'll just touch on briefly, human rights law. It's very expansive. This protects also employees, but it makes it unlawful to deny the use of facilities or to permit the harassment of any student by reason of that student's race, color, religion, disability, sexual orientation, national origin, citizenship, gender identity or expression, military status, sex, age, marital status, or status as a victim of sexual assault. GENDA in 2019 was an amendment which furthered the protections under the human rights law to expand to actual or perceived sex, gender identity, or gender expression. Title IX of the Educational Amendments of 1972, Title IX goes far beyond equity in sports. It actually it prohibits sex discrimination as a major component of what it does as a law, as a federal law. Title VI of the Civil Rights Act of 1964, that prohibits discrimination on the basis of race, color, or national origin. And then, of course, Section 504 of the Rehabilitation Act and Title II of the ADA prohibits discrimination on the basis of disability of students. Your DASA policy at Waverly is actually on your website. You can go to, again, the school district's Board of Education tab, policy documents, and it's located there. So let's jump in and try to unpack some of what DASA does and protects in those definitions. So the definitions: harassment, discrimination, and bullying. How do you violate DASA? So DASA violations found if there's harassment, discrimination, or bullying, which has or would have the effect of unreasonably and substantially interfering with a student's educational performance, or reasonably causes or would reasonably be expected to cause a student to fear for physical safety, that reasonably causes or would reasonably be expected to cause physical injury or emotional harm to a student, or occurs off school property and creates or would foreseeably create a risk of substantial disruption within the school environment. Those are the violations. Discrimination and harassment are defined as you have to prohibit discrimination, negative treatment towards any student or another student that's based on the student's actual or perceived race, color, weight, national origin, ethnic group, religion, religious practice, disability, sexual orientation, gender, or sex. The Crown Act furthered DASA's definitions of protected bases and stated that protective hairstyles such as locks, braids, and twists are also a legal basis to find harassment or discrimination. discrimination. DASA is expansive, though. It goes beyond those legal titles that I just went through, and it, in fact, protects students for any reason. It's an including but not limited to definition. So you have students who are picked on or bullied or harassed, discriminated against because they're a nerd or they're goth, they dress goth, or a student likes certain music, or the stature, they're big, they're tall, or they're small. Bullying is the other component of DASA, and bullying is unwanted aggressive behavior that involves a real or perceived power imbalance. The U.S. Department of Ed and New York State Ed use that and adopt that definition. The power imbalance could be physical strength, it could be access to information, or it could be popularity. Intention to harm is another component that's looked at for bullying. Repetition, generally it occurs more than one time. And examples could include verbal, social, physical, or cyberbullying. Prevention recommendations for staff. You want to try to eliminate discrimination, harassment, or bullying by gathering information from students. You want to learn and identify early warning signs. You want to establish and enforce classroom and school rules and provide adequate supervision, especially in those less than structured areas, hallways, cafeterias, and playgrounds. Your reporting obligations. This is so important as a Waverly staff member. If you receive a complaint, a verbal or written complaint from a student or parent or guardian, you have to pass it along. Your obligations are, if you receive a complaint or you witness harassment, bullying, or discrimination yourself, you have to verbally notify the principal, superintendent, or Dignity Act coordinator not later than one school day after you witness or receive that information. After that verbal notification is made, you then have 2 school days, up to 2 school days, to make the verbal report. Make a written report after the verbal report. The DASA investigation will then take place. This principal, assistant principal, or superintendent, or the Dignity Act coordinator has to conduct a thorough investigation. They're looking for whether a material incident has occurred that violates DASA. When the investigator believes that any kind of conduct is criminal in nature, they would of course pass this along to the appropriate law enforcement agency. Following the investigation, staff are not privy to what happens next. It's protected and confidential. But in the event there is a material incident, there is a violation of DASA, the school district must take prompt actions reasonably calculated to end the harassment, bullying, or discrimination. They have to work to eliminate the hostile environment, prevent the recurrence of the behavior, and ensure the safety of everybody involved. Methods to accomplish, so some things that might be done are progressive discipline, so it could be of a student or it could be of a staff member. If you do engage in progressive discipline for a student, it has to be measured, balanced, and age appropriate. And then restorative approaches might also be implemented, whereby you sit down and you have a peer mediation session or a re-entry meeting amongst the parties to try to ensure that everybody's comfortable and safe moving forward. Retaliation is prohibited, so if you make a good faith report of a DASA violation, you are immune from civil liability. You're not subject to civil liability. That's Educational Law Section 16. Let's touch upon a topic area now that is in kind of a state of confusion. So in 2025, what law controls? We have federal law and we have state law, and we have a lot of current events, and you see a lot of news articles where there's a tug, a pull, push and a pull on federal and state law. So in New York State, this 2023 guidance document that you're currently looking at is controlling as far as treatment of transgender and gender expansive or TGE students. New York State includes, as part of DASA and as part of the human rights law as well, it protects students on the basis of their actual or perceived sex and includes a person's gender identity or expression. SED, that policy document that we just looked at, states that TGE students have to be treated as follows: names and pronouns. TGE students should be addressed by the name and pronoun that they themselves have expressed. You do not need to require, or you do not require, you're not able to require a parent or guardian consent or a court order before you start using that name or pronoun. School staff are responsible for ensuring the students are referred to correctly, and it's a violation of human rights law if you intentionally refer to a student's name or pronoun incorrectly. Gender-based activities, rules, and practices should be discontinued. So if you have a policy in the school to use certain colors, imagery, symbols that are typically associated with a female or a male, you are to discontinue this unless there's a clear pedagogical purpose. Restrooms and facilities. TGE students are entitled to use the restroom that aligns with their gender identity. Of course, we know that the use of single-stall gender-neutral restrooms in our school buildings is a requirement under New York State law now. Denying use of restrooms or facilities because of a person's gender identity is a violation of human rights law and is unlawful discrimination. And GENDA prohibits schools from asking a TGE person to use a single-stall restroom because of somebody else's concerns. Privacy and confidentiality, just to touch on this, FERPA prohibits improper disclosure of PII, that's personally identifiable information, and a TGE student legal name, their name at birth, must be kept confidential when their affirmed name is being used unless there's a legitimate educational interest. Again, conflicts in federal and state law. To just summarize this, we just talked about DASA and New York State's robust protections of TGE students. This does conflict with the current status of federal law. On August 1st of 2024, the Biden administration did update federal law. Federal regulations were updated to expand the definition of sex discrimination to include sexual orientation and gender identity. That was undone in early January of 2025, when Texas versus Cardona vacated the Biden administration rules and stated that OCR, the Department of Ed, exceeded its authority. 2020 regulations then went back into effect. Those were adopted by President Trump. President Trump takes office a few weeks later, and a host of executive orders are issued on these topics. And then New York State pushes back. So we see a Dear Colleague letter from the Office of Attorney General in New York State, as well as SED, the Commissioner of Education, one from February 2025 and one from May 2025, that indicate, hey, New York State schools, remember, we have robust protections of TGE students from harassment, bullying, and discrimination. You must follow New York State law. You're linked to state aid, state funding, and of course, the federal government's message back is, hey, federal funding issues here, you must comply with Title IX in our federal laws as well. So there's a back and forth. Know that it's real. It is frustrating and very confusing, but it's it's what we're living with right now. Sources and information for all of you. You can, of course, visit New York State's website. There's a whole page with many links dedicated to Dignity Act and these protections that we discussed today.